part of the common lands, which means that they're for the general use of the community as a whole. So there was prados, or pastos also it's called, which are the high-yield pasture lands. These are lands used for growing forage. Dehesas is a term, pasture lands that might also be cultivated. Ejidos, unfenced land used for open grazing and other customary common uses. Propios or consejiles, these were the municipal lands. They could be used for cultivation, or they might be for plazas, they might be for cemeteries or orchards. And then also the baldíos, which were uncultivated lands surrounding communities. So you can see it just in the notion of how we relate to land is complicated, right? Because it's multiple different types of uses. It's the montes, it's the rios, it's every sort of thing on those resources that have these sort of different things. And so you can't talk about common lands without talking about the uses of the common land. So first off, all waters within the land grant were available for common use to everyone. So there's this concept of common water that I'm going to kind of keep talking about, and I'll keep bringing up. It's something that is important in our communities. Finds its way in sort of our history of use. Common lands are used for the harvesting of fuel wood and for building materials, whether it be timber, could be earthen materials like rock or dirt, clay for adobe. You'll see when you go to different land grant communities, whatever was the most abundant resource is what the houses were made out of. So some are made out of jacales, some are made out of rock, some of them were more adobe. So whatever was closest and the best used material in the community. Harvesting of wild fruits, nuts, herbs, basically any kind of vegetation materials that could be used for either consumption, for food, or even for remedios, religious or spiritual purposes. Hunting and fishing, very important. Livestock grazing, and I know nowadays it's interesting because a lot of the translations come out to be cattle, but in a lot of our history, a lot of it was actually sheep. Livestock was sheep. And then religious and spiritual uses. So this includes, for the construction of churches, for the construction of cemeteries, pilgrimage areas, calvarios. And I want to point something out I think that was really cool that I found in the San Miguel del Vado granting documentation. And this is the document that actually granted them the grant. And it says, and when it's kind of spelling out all the lots that are going to be divided, and another small surplus portion, which by the consent of all, is set aside for the benefit of the blessed souls in purgatory, on the condition that the products are to be applied annually to the payment of 3 masses. So this was likely used for a cemetery, and the areas that weren't, where the cemetery had not yet been filled, there was probably crops that were grown, and the production use of those crops was going to pay for masses for the souls of those dearly departed from the community. So you see, this notion to us is that the land sustains us not only when we're here on this existence, but it's also providing for us in our next existence. That's a deep spiritual connection to the land. And so when folks say, well, why all the fuss? Or, like, how are you guys still fighting over this issue? Because that connection is that strong. To give you an example of that, the San Joaquin del Rio de Chama Cemetery. This is a cemetery in a land grant that was a U.S. versus Sandoval affected grant, where they lost most of their common lands. And then, not only did the patent finally get issued for the community, for 1,500 acres out of 400,000 acres, the patent didn't even go to the community. It went to the Rio Arriba Cattle Company, Land and Cattle Company. And the community was systematically removed from the land. So you have a cemetery that was, so it's interesting because the cemetery actually ends up on the U.S. Forest Service as part of the lands taken by the U.S. versus Sandoval decision. The 1,500 acres is eventually bought by the Forest Service in the 1970s by a private owner who kind of come to own the property, and the community had been locked out of it. So in 2015, after almost a decade of negotiation, the land grant receives an easement from the U.S. Forest Service, and this was like almost required an act of Congress. Took a lot of lifting. So they get a community cemetery that they've been locked out of since probably the 1920s. They get access, and this is I have this written down wrong here, but the U.S. Forest Service didn't acquire the cemetery in 1970. They acquired the land adjacent to the cemetery. And one of the things that they wanted to do is they wanted to include this as part of the Rio Chama wilderness. And so when the Forest Service gained control in the 70s of this cemetery, the community who was displaced never forgot their ancestors in the cemetery. They immediately started going back to try to use the cemetery. And they actually wanted to be an active use cemetery. And one of the things that the Forest Service did, because they didn't want them in there, is they said, this is part of the wilderness. And the boundaries hadn't actually been established yet, but they used that as a means to keep them from going and cleaning the cemetery. And they put, actually on the fence of the cemetery, they put up wilderness boundary signs. And so, you know, for communities, what hurt that brings for communities, right? So we were able to get to a one-sided easement, in my opinion, because it gets renewed every 30 years, and it's like one-sided in the fact that the U.S. Forest Service can change the terms, and it has the same force and effect. But the community had said, we need something rather than nothing. So now they have the easement for the cemetery to be historic. They still can't bury in there, but they also have an easement for access, so they're entitled to get into the cemetery. So we want to look at the origins of the common lands in the law, and I want to sort of, we're going to look only at the common lands in the written law under Spain and Mexico, but I want to be clear that there's this notion of common land and ownership is something that's ingrained in us also from our Native American side. Right? Like our communities are a mixed mestizo communities. They're made up of geniceros. Just to give you an example of this, again, looking at the San Miguel granting documentation, when Lorenzo Marquez goes before requesting the Spanish crown to get this grant of land, it's on behalf of himself and 51 other settlers. Well, that's 51 other families, and included in that are 13 Indians, 13 Indian families who are petitioning. So this kind of concept of land and law and ownership, it's something that's, communalness is something that's ingrained in us from two sides. When we look at the origins in Spanish law, I know Dr. Garcia Griego mentioned yesterday the siete partidas. The siete partidas were a codification of laws based on sort of Roman law. And one of the partidas, the third partida, the third division, Title 28, Law 9, says separately, and this is a medieval 1200s, right? Medieval law. Separately, the commons of each city or village are the fountains and the squares where the fairs and markets are held, and the places where the councils meet, and the sandy areas on the banks of the rivers, and the other ejidos, common lands that have a good translation there, and the places where horses run, and mountains and pastures, and all other places similar to these that are established and granted for the communal benefit of each city or town or castle or other place. And every man who dwells there can use all these above mentioned things, and they are common to all, both poor and rich. But the inhabitants of another place cannot use them against the will and without permission of those who live there. So they're common, sort of like public, but they're public and common to the local community. And this is going to be important later. So after the siete partidas, in 1680, we have the recompilación de las leyes de los reinos de las Indias. This is at the same time we have the Pueblo Revolt going on here in New Mexico. But these were the laws that were really applied for all of the sort of Spanish settlements that were taking place as part of the conquest throughout the Western Hemisphere. And the recompilación, it pulls together laws and decrees from various centuries, right? So there are some that kind of conflict, but there's some common themes that kind of come out. And I just want to give you some of that flavor, right? So in Title 5 of the list, you have the very first law. Lands chosen for settlement shall have pastures for raising livestock, forests, groves for wood, and good water for drinking and irrigating. Law 6, if the nature of the land is suitable for settlement of a town, with the council, so right away it calls for a governing council, these are government entities. It must be more than 5 leagues away from any other city or town, right? Because those lands are for that local community. And also, they shall cause no harm to any town of Indians or any individual. So they're recognizing the fact that there are these rights inherent to these areas. Law 7, enough common lands and pastures in which the livestock that the residents have may graze plentifully, and an additional portion for the town itself. So remember those different categorizations of common land Some is the common land to the town itself. Law 13 of Title 7, common land shall be extensive enough that the settlement, as it increases, there may always be enough space for people to reproduce and for livestock to graze without causing damage. It's funny because this term reproduce in Spanish, it's actually recrear, and a lot of people have started to interpret it to say recreate. And it's like, no, it's not recreate, it's recreate.
It's the same thing, no?
Yeah, that's a good one. So, Law 5, residents shall have the use in common of all pastures, forests, and waters, and in the provinces of the Indies. Law 8 of Title 17, wild fruit in the forest is to be used for the common good. Law 9, the viceroys and audiencias shall consider it a matter of good management of the pastures, waters, and public buildings, and they shall make provisions as necessary for settling and preservation of the land. This is an interesting one, Law 11. And again, it goes back to this notion that there was already some things established here in terms of custom and customary law. We order that the same regulations followed by the Indians in dividing and distribution of water shall be observed and followed by the Spaniards, among whom lands are apportioned and assigned. For this reason, the same natives who were previously in charge of shall manage watering of the lands, and the water that each must have shall be given to each one in turn. Penalty for violation of this regulation shall be that he who wants, takes, and uses the water by his own authority shall be deprived of it until those in line after him have been watered, the lands assigned to them. So he who's first shall be last, right? And they give the natives who know the environment and know the system the authority to distribute the water. So yesterday they talked a lot about the acequias and customary law and how important that was. Law 14. It is our will that the Indians may freely cut wood from the forest for their own use. We command that no impediment shall be placed in their way, provided that they do not cut the trees in such a way that they cannot grow and increase. This notion of conservation and preservation for future people to use. So after the siete partidas and the recompilación de las leyes de las Indias, we have something known as the Plan de Petite in 1789. This is really a plan for a very specific community in Mexico, now known as Hermosillo. But what's interesting is this plan kind of, let's say, sets the template, and it really shows how the development of this plan is going to comply with the leyes de las Indias. And it's kind of the first comprehensive plan, I guess you could say, for communities, so it's really early planning. So this is kind of cool where the law and natural resource planning come together. And then after the Mexican period in 1821, from about 1823 to 1846, you have various Mexican colonization laws that are passed, and those will determine who has the right to grant, who is granted authority, what are the size of these areas that are granted. So one of the things I want to share with you is something that I find very interesting. This is from the Tierra Maria land grant. It's an hijuela, which is a deed that was issued in 1863. So this is 1863, and these kind of concepts and notions that we saw in the siete partidas from the 1200s. This is the set varas, which were the lots that were given out. So this is after the United States has already taken over. A patent is issued for the Tierra Maria land grant, and the individual who the patent goes to, even though it should have gone for a community, he complies with custom, and he starts issuing out deeds for the lots within the land grant, and in each one of those deeds it says, the said waters of land retain the rights of pasture, water, firewood, timber, and roads, free and common without prejudice to a third party, nor to the owners, as in all settlements made and granted. Over 100 of these were issued, and the community relied on these. We'll talk about that a little bit more. Can't talk about the common lands without talking about the loss of the common lands, because that's what's had the most significant impact to our land grant communities. Because your way of life, if you have that complex of a system of just how you identify the different types of land and the uses of land, it's ingrained in your way of life and culture, the loss of that land is going to be devastating. 1848, the end of the Mexican-American War, Treaty of Guadalupe Hidalgo signed. The adjudication process, which you've heard about, takes place. It's long, it's cumbersome, it's not fair, it's unjust to a lot of our communities. The courts have an impact after Legislative policy also plays a role, right? You actually see kind of ebbs and flows between what's happening locally, what's happening nationally, and we're going to talk about some of that. Can't get into all of it just because of time, but... So the Surveyor General process, 1854 to 1891, the Surveyor General reviews claims, reports them to Congress. Congress acts in a just and proper way to give full effect of the Treaty of Guadalupe Hidalgo, so it requires congressional action to a patent. And until Congress acts, any lands covered by a claim can't be sold by the Surveyor General. So it causes sort of a backlog, right? I want to give you some, just a look at some of the actual patent language. So this is from the town of Antonchico land grant, and this is the language from the patent. Should only be construed as a quit claim, as quit claims or relinquishments on the part of the United States, and shall not affect the adverse rights of any other persons whatsoever. So I couldn't see what it's saying. The Tierra Maria grant, similar language. This patent shall only be construed as a claim, or as a quit claim or a relinquishment of part of the United States, and shall not affect the adverse rights of any other person or persons whomsoever. This is going to play an important, this language is going to hurt us later. So in 1857, you already have the U.S. Surveyor General process going on. The local and territorial legislature passes the Acts of Limitations, and they do it again in 1858. And essentially what this does is it limits the time frame for anybody to challenge property ownership from any lands granted by Spain, Mexico, or the United States. And they say those challenges have to come within 10 years. If they don't come within 10 years, then the third party is forever barred from making a claim. Wow, if this thing would have stayed enacted and it wouldn't have gotten sort of taken advantage of, we might still have some land grants with common land. Also in 1864, they passed the legal right to property, and it provides for, again, remember the adjudication process is slow. It's trying to work its way out, and the local legislature is trying to figure out ways to address that. So this provides for lawful claim of property and legal ownership granted by Spain or Mexico prior to the Treaty of Guadalupe Hidalgo, and it says that anyone who has a prior claim is entitled to lawful claim of ownership exclusively and against any other persons whatsoever will lay subsequent claim to that date. Don't know the exact legal history on this, but I can, you can kind of see, like I mentioned, where you see some of the local folks trying to do some things to protect communities. Then in 1876, Partition Suits, David covered this pretty well. This basically gives the right for individuals who have an ownership claim, even if they don't possess it, to sue for partition and force the sale of the land. This happens in 1876. This is the height of all that land speculation that the U.S. Surveyor Generals themselves, Surveyors General themselves are involved in. Skip that one. Around the same time, we have that 1874 Act for Acequias, actually empowers them to create laws and regulations for dealing with mining on the community. You also have the Las Vegas and Cañada de Gemes that we talked about earlier, establishes a process for the commission to oversee the private and public lands on the grant. The Chile Land Grant in 1876, again, distinct and different from the other one. But what's cool about this one is it establishes a board of 5 trustees to be elected every 2 years, whose duties shall be to pass such ordinance as they deem necessary for the protection of the common property of the grant. They end up losing the majority of that common property because of taxation issues under statehood, but this is, the intent is clear here. 1891, those general acts I talked about, the Article 2 grants, gives them the authority to regulate the sale and the mortgage of the common land, gives them the authority to oversee the common lands and common waters. This is an important point, something that's been ignored by the surveyor, by the attorney, State Engineer's Office, and actually they're against it now because we've been trying to get a definition of common waters, because we know there are areas where there's these waters that are used by communities that have been used since the grants were issued, but they might not have any kind of declaration on them. We encourage land grants to file declarations, but there's these uses that, oftentimes the State Engineer's Office will try to say, hey, we're going to give you the use when the improvement was created. So even though you've been using that spring all this time, you didn't really improve it till 1967, so that's going to be your priority date. So we look at the Court of Private Land Claims in 1891. So this is going on at the same time that those statutes are being passed. And it's created because of a lot of the stuff that's happening with some of that land speculation. One of the things that they made clear again is that this shall not affect any private property rights of persons between themselves and the claimants. Because before, remember, the U.S. issued the plan to Congress. Now the court itself can actually approve the title to properties. So there was been a lot of talk about the U.S. versus Sandoval case from 1897. That was decided on May 24th, and it resulted in the loss of millions of acres of land for 7 specific land grants. Well, that case actually relied very heavily on the United States v. Santa Fe. United States versus Santa Fe was decided on March 1st of 1897, so just a few months prior. And this court case dealt with the city of Santa Fe saying, hey, we're entitled to having a square league because we, by virtue of the fact that we existed, we don't have title papers, those were lost because it's such a long, old history, but we should, by virtue of that, get title, right? And so they look at the laws and say, well, is that in fact the case? And in their analysis, they look at some translations, and I want to focus on those today. So they rely on some translations to say, this proves that under Spain, which then became Mexico, which then became us, the sovereign in establishing these land grants they always retained ownership. The common lands never belonged to the communities. They never belonged to the municipality. They belonged to the sovereign. So this first, they look at Book 4, Title 7, Lot 7, and they say, the land shall be necessary for a site in a town, shall be sufficient liberties and abundant pastures, dehesas for cattle to be owned by inhabitants, which shall belong in the lands that belong to the town. So they use this term liberty to translate ejidos, right? Well, a liberty is it's a middle-aged term for an area of land which the regalian rights, so the crown rights, and this is in England, was revoked, and the land was held privately, not by the sovereign. So it was held privately by the community usually. So they used the term liberty, and they knew what liberty meant, and they still said it belonged to the crown, even though this specifically means the opposite, right? They also look at this thing about the lots, and they say the lots shall be distributed among the settlers by lot, beginning with those adjoining the main square, and the remainder shall be reserved to us to give as rewards, mercedes, to new settlers or otherwise according to our will, right? So they say, they interpret the remainder to mean everything except for those individual lots given. They're like, it's, what are we talking about? What's remaining? And they say everything, all the commons, everything else. Well, no, the remainder is actually talking about the lots. Because in these plans that you divided up towns, you determined how many lots there were going to be. So if you had 50 settlers, but there was enough room for 60 lots, well, there was 10 extra lots that you could then give out. So it's really not the commons, it's not the ejido, not the dehesas, not the propios, it's just those lots. They also rely on provision 14, title 12 of book 4, and they say, this law itself illustrates the absolute control thus exercised by the King of Spain over the subject of retaining ownership of the common lands, right? But they don't even put the translation in the thing. It's actually in the margins. It's a footnote, so they don't actually put the translation. But if you look at the translation, this is the law that they're referring to, and what's underlined is what they emphasize in the case. They actually italicize this section, that all the lands which is held without just and true titles be restored as belonging to us being the crown, in order that we may retain before all things the lands which may appear to us and the viceroys and audiencias and governors be necessary for public squares, liberties, reservations, propios, pastures and commons to be granted to the villages and councils already settled, with due regard well to their present condition and their future state, and to increase that they may receive. And after distributing among the Indians whatever may justly want to cultivate, sow and raise, confirming to them what they now hold and granting what they may want besides, all the remaining land were reserved to us, again to the crown, clear of any encumbrances for the purpose of being given as rewards, mercedes, or disposed of according to our will, our pleasure. Right? So they focus on this, in order that we may retain before all things all the common lands. So they interpret it to say that that's what it is. Well, if you look at the actual language, the language says para que reservando. And para que reservando, in my interpretation, doesn't say in order that we retain. And if you look at the translation from the American West Center from the University of Utah, they actually did translations of the leyes, and they interpret it this way: thus, before all things, there shall be reserved that which we or the viceroys and audiencias and governors consider necessary for squares, public lands, municipalities, and properties, and vacant lands, and the places and municipalities that are settled now or in the future, right? My own modern day translation: in order to reserve before all things what to us, or to the viceroys, audiencias, and governors, we deem necessary for the plazas, ejidos, propios, pastos, barrios, of, meaning belonging to the communities and councils which were settled, for both what is currently needed and what is needed in the future. And you got to look at the second half. And after distributing among the Indians whatever they justly want to cultivate, sow, and raise cattle, confirming to them what they hold and what they may want besides, all the remaining lands may be reserved to us. So what's remaining? Well, not the plazas, not the ejidos, not the propios, not the common lands. That's not what remains. They're setting that aside for those communities, and they're taking everything besides that. Not the lands of the Indians, including what exists now and what is needed for the future. So they recognize this notion that you got to give them enough that's theirs to control and manage. So this misinterpretation, in order that we may retain all the plazas, all the common lands, versus recognizing lands that are to be retained, to be held apart from what the crown keeps. That mistranslation cost over 1 million acres of land for 7 land grants that are still feeling the impacts and effects today. This was the basis for the establishment of the United States Forest Reserves, which becomes the U.S. Forest Service today. So all the major forests we have here in the northern part of the state, central northern part of the state, derive from this court decision. We talked about this yesterday, but just 2 days ago, our congressional delegation here in New Mexico, 4 members of the delegation, Senator Heinrich, Senator Lujan, who was the main sponsor, Senator Teresa Leger Fernandez, who's the main sponsor on the House, and Senator Representative Leger Fernandez and Representative Melanie Stansbury, who's a co-sponsor, introduced legislation to strengthen land grant community rights. And this is Senate Bill 2708 and House Resolution 5493, known as the Land Grant Mercedes. I know it's a mistranslation, but that's the title. Land Grant Mercedes Traditional Use Recognition and Consultation Act. And the purpose is to provide recognition for traditional uses on former common lands now managed by the federal government. So these are all those lands that were taken as part of that process or acquired thereafter, giving us connection back to those lands. We were successful at getting it passed in the last legislative session, so in December. We got it past the House, U.S. House of Representatives. Now we introduced it in both the Senate and the House, and we're hoping to get it fast-tracked through the House and move in through the Senate process. So 1907, again, the Community Land Grant General Provisions. In terms of land grant common lands, it recognizes their control and authority to manage the grant real estate in the commons, to sell, convey, lease, or mortgage the land grant common lands. All of this language permeates even today in our current statute. No right to sell or mortgage land without approval, initially of the community, now by the district court, to prescribe the price to be paid for the common lands and prohibit those who don't pay their share from using the common lands. The right to institute actions of ejectment for individuals who are illegally claiming portions of the common land, right, that gives the court the authority to entertain bills of complaint to enjoin persons from trespass on the common lands or using the common waters. So how does the court look at this? In 1913, right after statehood, we have a case that goes before the U.S. Supreme Court, Bond versus the unknown heirs of Varela. And what this is we have some individuals who are suing, and it's interesting because the attorney who's suing in this case ends up being the Supreme Court justice in the next case we're going to talk about. But they're suing because they're trying to take the common lands of the grant away from the town of Tomei grant. And so they're suing to say, hey, we have a claim and we're trying to partition. They're actually trying to follow the partition laws and partition is granted and forced to sale. And the Supreme Court actually says, when the patent to the entire grant issued to the town of Tomé, title to all the unallotted lands passed from the United States to the town unburdened with any trust for the heirs or grantees of persons named in the original petition or decree. So this guy's trying to use a claim from an original grantee to say, hey, I got his interest and I want a partition. And the Supreme Court says, you can't do that. When the United States issued that title to the town of Tomé, it quit all the interests of the individual heirs. So it actually got it right, kind of, for us, right? In this instance, for land grants. So the result is that it recognizes the land grant commons belong to that corporate entity and not to the individual, so they can't partition. Well, victory for the community, right? 4 years later, in the New Mexico Supreme Court, and the attorney prosecuted that, or who was moving against the land grant in that last case, is now on the Supreme Court of New Mexico, and he's one of the justices who issues the decision. And they determined that the Court of Private Land Claims was bound to respect the land. Oh, I'm sorry, I jumped ahead. In fact, I'm going to skip this one because of time. This is essentially a grant where you have two land grants suing each other because the Court of Private Land Claims got it wrong on the boundaries. And they said, no, even though third-party rights aren't adversely affected, it doesn't count when it's a land grant against a land grant. This is the case in 1917, same year. Board of Trustees of the Assembly at the First National Bank of Albuquerque, versus the town of Tomé. The New Mexico Supreme Court case decided, and what they determined is that by the confirmation of Congress to the town of Tomé was nothing more than a relinquishment or a quit claim deed. Remember that title or that language from the patent. And it was intended or accomplished, and the adverse rights being accepted were not affected if valid. For this reason, the alleged superiority of the appellate's title, depending upon the confirmatory act of Congress and the resulting constructive possession following such alleged superior title, falls to the ground and need not be considered. So even though the Supreme Court said, hey, those guys have superior title, the attorney who was on the other side, who's now in the Supreme Court, says, nah, that falls to the ground. They don't have that authority. They didn't actually get that right. And they say the plaintiff's right of action is based on adverse possession of land within the land grant. And if that possession has been good for 10 years, then they have a valid claim, right? And we're going to give preference to that individual. Well, let me make it clear. The First National Bank of Albuquerque, this is a property that they have, which they acquire from an individual who moves into the community of Tomé and claims some property based on a deed that he says he purchased in like 1885, I think. By 1893, the community has tried to eject him. They enjoin him. They move for ejectment. The court recognizes ejectment. He's claiming 3,000 acres. The court recognizes that he doesn't have valid right to 77 acres. Must be where he lived because they eject him, and then he leaves. He leaves the community, abandons it. Sometime later, I don't know if he uses it for collateral or what, but the Bank of Albuquerque ends up with this property that they claim they have title to, right? And so this guy wasn't even there for 10 years to perfect the adverse claim, but the court relies on the fact that, oh, well, there's a chain of title there that, we're going to follow. And it's interesting because the court even says, it might as well be argued that the right of the town of Tomé, which arose as to the common lands after confirmation by Congress in 1858, should have been prosecuted by the proper proceedings prior to 1868 or be forever barred. So that, that law that said you gotta make a claim after 10 years or be forever barred? Well, they're saying that the landlord got a patent, but they needed to perfect their right to the common lands, and if they didn't do it in 10 years, well, they're forever barred from making that claim. So what's interesting is that under this process, the individual who's claiming title, he has title through a grant that was made by a prefect. Well, the courts have already decided that prefects under the Mexican period didn't have the authority to issue grants. And so the court says, well, we know that the prefect probably didn't have the power to make a grant, but we're not even going to actually look at that issue. We're going to say that because he got a deed from a prefect, it's still color of title, and we're going to go ahead and say that, yeah, this guy adversely possessed this 3,000 acres, which, by the way, had a community spring, right? And so would a community have given privately a spring that the whole community relied on for grazing? Likely not. But as a result, the First National Bank prevails, and it sets up a precedent that land-grant common land can be adversely possessed. So this takes us to 1940, and there's a case with the Tierra Maria land grant. Here you have the same thing. The community using those deeds says, hey, we got over 100 documents that between 1861 and 1866 that entitle us to the rights to the common lands. They can't adversely possess something because we have rights and interest in those common lands, right? And that's the argument that they make, and they have all this documentation, and the court says, well, this is intriguing and its ramifications, and by its vigorous challenge to the appellee's title, we need not and do not decide this. Another question is whether the appellee has acquired title by adverse possession. In any event, also presented and relied upon is decisive, and it would serve no useful purpose to discuss further or pass upon such other points. So they don't even address that issue. The court just chooses to ignore it. And as a result of it, they say, yep, we've already decided this, that the title can be passed by adverse possession, and for the common lands and community grant, that's something our court has already weighed in on in this other bond case. And then they also, it's interesting, they cite the Kavanaugh case, and they say, we held that the Tecolote land grant is not a municipal corporation in the sense that it constitutes an instrumentality or agency of the state. So they say, not only we can adversely possess it, and because they're not a unit of government, they don't have any rights protected there. So in the end, the court relies on First National Bank of Albuquerque versus Town of Tomé. It says, yep, we've considered this. You can adversely possess the land. And the result is the third-party interests of the heirs are ignored in favor of the adverse possession of the common lands by the outside third party. So, those heirs had a third-party interest, but the court said, nah, in this case, we're not going to look at it. There's another case that gets even worse, in my opinion, and more egregious, but for sake of time, we're going to move on. 2004, though, we finally kind of get a win. Board of Tecolote land grant versus Griego. This is a case where the Griegos are claiming about 572 acres of land. I guess, did you prosecute this?
I tried that case, and won.
Nice. Well, thank you for that.
And then the Court of Appeals reversed.
Oh, so you were on which side?
Well, I was a whole, that case established, thanks to me, a very high bar
Yes.
for asserting adverse possession against the land grant.
Yes.
And I won on adverse possession in the trial court, and I was reversed because the Court of Appeals thought that my clients were strangers to the grant. It's a good decision. So they don't want people willy-nilly claiming adverse possession against land grants. And I couldn't convince the Court of Appeals that we're not the usual stranger to the grant. We're heirs claiming adverse possession, which we convinced the district judge of, was lost on the Court of Appeals. So I lost it for my clients, but it's a good case for land grant.
Yes, this is true. Because what this found is that you cannot adversely possess land grant as an heir. There's a heightened requirement, right? Particularly when the co-tenant is a land grant. So if you're a co-tenant, you can't just adversely possess an heir because you're out there doing your uses is something that's consistent with your normal use of the grant, and you really have to give more notice. So this is actually a good case for land grants in 2004, where the Court of Appeals rules in favor of the community. And then we look at the legislative process, right? And so in 2004, we addressed the fact that units of government and that whole adverse possession question by getting the statute changed to political subdivision status for most land grants. And then as Representative Garcia alluded to earlier, that adverse possession statute, that land grants can no longer be adversely possessed after this act was made effective, if their claim hasn't vested prior to the effective date of this act. And the effective date was June 15th of 2007. So if you didn't have a perfected claim prior to that date, you're forever barred from making an adverse possession claim against the land grant thereafter. So it's a good fix. Came 100 years late, but still a good fix. And so the general provisions, just want to talk briefly. How much time do I have?
I think about 15 minutes.
About 15 minutes. Okay, so I'm going to go through these. These are the general provisions that exist as they relate to land grants. Management and control is vested in the Board of Trustees to care for, control, and manage the land grant and all of its common lands. It gives them the authority to convey, lease, or mortgage the common lands. consistent with their bylaws, as well as another section of the law that I'll talk about. Determine the number of animals to be used and the prices to be paid for the use of the common lands. Prescribe the ability for the use, and if you're in default, for the land grant to bar you from using it until you come current. To make bylaws, rules, and regulations not in conflict with the Constitution of the United States or the State of New Mexico that may be necessary for the protection, improvement, and management of the common lands and real estate, and for the use and enjoyment of the common lands and of the common waters of the land Grant-Merced. Determine land use, local infrastructure, and economic development of the common lands. Talked about this before. Determine zoning and convey a portion of the common lands shall only be effective. So a conveyance, this is the important part for conveyances, is they're only effective if, one, they meet all these elements. It's made in accordance with the bylaws and this section. It's made for the benefit of the land Grant-Merced. So there has to be a benefit for why the land is being conveyed, for the land Grant-Merced. The Board of Trustees has passed a resolution for the conveyance, and they've held their meeting in accordance with the requirements of the statute, which is a 10-day notice, 10-day public notice. And then the board has to petition the court, the pertinent district court, asking them to affirm their resolution. And the district court has to issue an order affirming that the resolution was done correctly and that they met the elements, that it was for the benefit of all those things. And so this process also allows for an heir who wants to protest. They have the ability to protest that conveyance. So when the resolution's passed, they have 30 days to petition the board and say, I don't agree with that, and I want it to be relooked at. And then the board has 30 days to actually relook at the issue. If the heir is dissatisfied with the decision of the land grant and they still move forward with the conveyance, the heir has the right to protest this at the district court level. The rest of this just kind of spells out what the process for services. So, and you can look at the statutes if you're interested in that area, who will pay for the proceedings. And essentially what it finds is when it's all said and done, if the district court finds that all the requirements have been met, then they can issue an order affirming the land grant's resolution, and then only after that point in time can the land grant issue a deed of conveyance on that property. So there's a heightened sort of requirement of what they have to do. Also 49.1.11.1, all persons who are not an heir who has purchased or leased the properties of the land grant only have what they interest in their own private property. They do not have an interest in the common of the grant. It also, provision B of that also says that the Board of Trustees shall not have any jurisdiction or management over private properties within the grant. It's restricted only to the common lands of the land grant. So that's 49.1.11.1. And then 49.1.15, removal from the land grant. So this deals with removing somebody who is ejectment, essentially, the process for ejecting, bringing forward an ejectment claim against someone who's claiming a portion of the common lands. And then also they added on here that delinquency of an heir will end their right, so you're not entitled to use the common lands if you're delinquent. So you get caught up in a fool. And then again, the court has the right to entertain bills of complaint against trespass on the common lands and common waters of the land grant. So I want to leave or end with an important case that I referred to earlier, the Realan Resources Incorporated versus New Mexico Cultural Property Review Committee from 2014. It's a Supreme Court case, and this dealt with the Cebolleta land grant. There was a Traditional Cultural Properties Act in New Mexico allows for the designation of a property, a traditional cultural property, for public lands, and with that comes some heightened requirements for uses that can be done on the land and approval processes. And so what happened in this case is we had 5 tribes, I believe, that sort of pushed for Mount Taylor to be considered a traditional cultural property. And included in that process, they swallowed in the Cebolleta land grant common lands because they said, hey, in 2004, they became a political subdivision. Therefore, their common lands must be public lands. And we're going to include them without asking them or without sort of consulting them. They just said, we're going to include them as part of this traditional cultural property. And so as a result of that, it finds its way up to the Supreme Court. And here's what the court finds. The court says, look, our courts have long recognized that the common lands of a community land grant are jointly held as private property by the heirs of the land grant. They also reference another Supreme Court case, Moragon v. Tenorio, and they say that the common lands are not open to the public. They are private property. They may be leased. Only the heirs of the original claimants can use them for wood gathering and similar purposes without lease or consent of the trustees. They also cite Armijo versus Cebolleta. Again, as a practical matter, the legislature has assumed the function of exercising its rights over those land grants and administration, so they reference that case. They also reference the Board of Trustees versus the Town of Las Vegas, 1971, that the principal function of the Board of Trustees is to hold title to and manage the common lands of the grant. So that's a principal function. It recognizes that because this was done where a legislative act created the opportunity, they said, well, because the legislature created them as political subdivisions, it would have amounted to a taking if it would have then created the common lands as now being public. So it said a legislative taking would violate the privately held rights of these land grant properties that have existed since the land grant's inception and have expressly been confirmed by our federal government under the Treaty of Guadalupe Hidalgo. That's great language for us, right? Incorporates the treaty. We actually have a change to the law because of this. Well, this is still going through the courts. We have a change that's made to the provision before the decision gets made, so it doesn't affect this decision, but it fixes the kind of loophole that was created. And the legislature says that the designation of land grant merced as political subdivisions of the state shall not alter the property rights of the heirs in the common lands. The common lands owned or controlled by the land grant merced shall not be considered to be designated or treated as state land. So it clarifies that fact. These are common to the grant. They belong to the local community, consistent with those old laws that we looked at. It also provided for land grants to enter into this memorandum of understanding so that we could maybe negotiate with the adjacent tribes that wanted to protect those areas, agreements concerning the protection and maintenance of cultural resources. This case also holds that the management, control, and governance of the community land grant includes those rights recognized by the Treaty of Guadalupe Hidalgo. And because this was two different statutes that were bumping up against each other, it was the statute for the land grants as well as the statute for the Traditional Cultural Properties Act. They had to determine which one governs, which one rules, and they said, we construe the two statutes in favor of the interpretation that complies with the international treaty, the New Mexico Constitution, because the treaty is in our Constitution, and our long-standing jurisprudence recognizing the private property rights inherent to a community land grant's common lands. So this is really good law for us from the 2014 Supreme Court case, where they're starting to at least understand a little bit better what land grants are and what they mean because of some of the legislative changes and because of sort of more education on the topic. And with that, if there's any time, 5 minutes for questions. Oh, 7 minutes. Yes, ma'am.
I'll go ahead and ask kind of the same line of questioning we were talking about during the break. So can you just explain, does the common lands include the mineral estate?
Okay, so this is a good question. It's whether or not land grant common lands includes the mineral estate. And like anything related to land grants, the answer is complicated and it depends. And the reason it's complicated and it depends is that the patents that were issued to land grants, some of the early patents initially, the United States government didn't fail to mention anything about mineral rights. So essentially, whatever was issued in that patent transferred whole. Mineral rights, surface rights, all that stuff, right? Well, a little bit later on in the process, the United States said, whoa, wait a minute, there might be some minerals that we want to protect on those common lands. And so when they issued those patents, they said, except for gold, silver, and quicksilver. So gold, silver, and mercury, they said, we're going to withhold that. We're not going to. Those you can't have. We'll give you everything. We quit our claim and our interest in everything but those valuable resources. So we have some land grants that have that in their patent. You also have, because some of the patents were issued in a weird way as these tenancies in common or because they were issued to the wrong individual, we have some instances where the land grant, the mineral estate was sold off with the community never knowing. So we do have some instances, and those, it's hard to trace, all of those. You got to know the intricacies. We have some land grants that think they have them, and then they come to learn that, oh, wait a minute, no, in the 1930s, Chevron bought them. Interestingly enough, there was a case, I think it was with Socorro, one of the grants down south, where they discovered coal. And the United States said, hey, wait a minute, is the patent, are they entitled to the coal? Because that's a mineral right that we withheld. And the court looked at it and said, nope, you guys said gold, silver, and quicksilver. Didn't say nothing about coal, so the coal actually belongs to whoever received the patent. So it's complicated, nothing related to oil and gas, because oil and gas wasn't even a thing when these patents were being issued and contemplated, so nothing related to oil and gas in any of the mineral states.
Hey, Arturo, you mentioned this provision that if a non-heir acquires land within a land grant, they're excluded from using the common lands. Do you think that's a good thing in terms of integrating people into the community?
Well, I'll tell you, that's a good, interesting question. I think that you can't look at it though without context and history, right? So initially, under Spain and Mexico, members came into the community, they could potentially gain access to use of the common lands because that was the way that things were settled. And you could leave a community and you could lose your rights and access to the common lands, right? Because those were for that community. But when you bring us into the American jurisprudence and some of these notions, right, it changes. So it becomes about heirship. It becomes also, you got to remember that when folks were coming into these communities during the period, the reason those laws came into place is because it was folks like Thomas B. Catron who were coming in and saying, I'm going to use it's mine, right? And they were gaining ownership, and they said, well, I have an interest, I bought this house that belonged to Jose Martinez, and because I own a house, Jose Martinez, I now have an interest in the common lands, and I'm going to sue for partition, right? And so those laws came about because it was bad actors coming into the community to not allow folks to come in. And so some of those are pretty old on the books, and that's the precise reason why they were created. In terms of looking at it as a matter of sort of policy now, that's a question, that's a future question I think our communities are going to have to sort of look at and deal with. And it's actually happened, right? One of the reasons why we had the change in the statute for allowing land grants to define what an heir is in the bylaw is because during the period where a lot of these lands were being lost to back taxes, you may have had new people who moved into the community who said, what the hell, man, this is important for our community. I'll pitch in and pay for some of those back taxes, right? And they became members of the grant. They became members of the community. And so those folks, and that's why the Truchas land grant, for example, still remains statute specific because they have quite a number of those folks who kind of bought into the grant in that way. And they didn't want to become a part of Article 1 because at the time it said you have to be an heir of an original descendant or you lose your rights. And they said, we don't want to screw over these people that are now the grandkids of the ones who stepped up to help us and who still are part of our community. So it has happened organically within each individual community. Any other questions? Nice. Well, thank you guys very much.